Honorary Retired Dr. Besigye has obtained retiring versus Uganda.
Next week. Yes. Nezizigenda lwakusatu. Lwakusatu lwokuna.
Last 10 or 11 months. I wrote on the question of the type. I just want to say one small thing. When I read the indictment, I don't see my young friend's participation in it. Signing, naming, drawing, anything. What he didn't say that he was part of. So he really can't explain the preference for ICB stated in that document. He can't explain it away as a type. It is a preference, a choice. Has no relationship with the document to say anything about it. Like my colleagues have submitted, it is not. So his explanation cannot repair or fix that very fundamental issue, which is the submissions of A1 is part of continuing illegality. I'm glad that Council for the State did not oppose the submission made by A1 about his illegal rendition. To deal with this matter if it affects that constitutional order. Of all days, not today. The court cannot shut its eyes to the constitutional order, to the right to a fair hearing, the issues being raised by the accused. My Lord, we leave it to the court to make the kind of decision that my learned friend for the state has said is within its discretion. To bear in mind that Article 28, Article 44, read together with Article 126 of judicial power, require the correct thing to do. As my land friend has submitted, is to save this file to its preferred destination, its original destination.
We appreciate the fact that this is a matter that is between them and court. Where prosecution can decide to mute, to be mute, or to go mute. And it is a submission, therefore, that this court has a discretion to decide on whether to continue with the matter given the complaint before the Judicial Service Commission or if it deems it necessary that it is conflicted in one way or the other. That one is discretion of this honorable court. And bias. It is a submission that prosecution has not detected any such signs of incompetence or bias on the side of the trial judge. My Lord, the alleged complaint before that was filed in the Judicial Service Commission against the trial judge is not a bar for you to handle or for a trial judge to handle this matter, which is properly allocated to you unless the Judicial Service Commission has properly brought that matter to your attention or the complaint, or it has determined it, or when it has determined it. In any case, this is not the first time we are hearing about incompetence and the issue of bias. When we were at Nakawa Chief Magistrate's Court, the applicants actually filed a complaint against the Chief Magistrate who committed the accused persons to High Court. Although, as prosecution, we were not, or we never got an opportunity to look through that complaint. The summary of it was raised by the accused's counsel that the trial magistrate was incompetent, biased. The only thing that has not been added here is the abuse of the process. What does this signify? It signifies the fact that the accused persons are serial complainants. But that said, my lord,
particularly by A1 and A2, that this application ought to wait your ruling on the matter that has just been reserved for the 15th. The issues are the same. Yes, my lord, maybe it can be emphasized a little more by Mr. Karibara, but they have objected to your proceeding with the matter. Is the matter before you? Issues are... Yeah. Okay. Yeah.
Where I say the proposal was made and there is a ruling. Second, the proposal was made. I don't think it's the application.
Okay. I yield to my learned colleague.
My lord, my learned friend here, Mr. Billy Vumbuka, labored to persuade you, albeit unsuccessfully, that there is a typo in the indictment, that it was a typing error. To say that the accused persons will be tried at ICD, that it was a typing error. That is the least I would expect from a state attorney of his caliber. With all due respect to my learned friend here, my lord, and I dare say, my lord, my learned friend was extremely dishonest in that submission. Extremely dishonest. And I will substantiate. My lord, if you looked at the record, that statement is in a court order signed by the registrar of the court. Signed by the registrar. It's not up to him as a state attorney to begin impeaching an order of court as being defective. It's not up to him. I don't need to advise him that if indeed that was a typing error, there is a procedure for court to correct its own record. under the slip rule and all these other procedures. He knows. That has never happened, that this matter was ever brought to the attention of the lower court that handled the pre-trial processes, where this record emanates from. Nowhere on record it's indicated that they ever moved the court to correct its record. Never. Secondly, my lord, my reading of this, there is no typing error. The word, the phrase actually, that you will be tried on the above indictment at the sessions of the International Crimes Division of the High Court. Well structured in perfect English. International Crimes Division of the High Court, boldly stated, with no typing error at all. So it is disingenuous on his part to begin purporting at this stage that there is a typing error on record. Related to that, my lord, again, the submission he made that he finds no issues with this honorable court proceeding with a matter which was supposed to be transmitted to the ICD, which was committed to the ICD, because these are committal orders. The committal order is that ICD, that he finds no issue with the file being diverted to Rongo Division. I want to substantiate the submission made by Senior Counsel Martha Karua, the lingering question how the file found its way here. I'm trying to figure out, my lord, the clerk who got the file from Nakawa Court with the orders, take this to ICD. How did this clerk end up here? How? You are armed with a file from the lower court, the magistrate court, deliver at the register of ICD. He or she decides to divert the file and bring it here. That speaks volumes about the propriety of the whole process we are trying to interrogate now. Then the last issue, my lord, on that particular matter, Mr. Birivumbuka submitted that these are all the same code. I mean, it's all the same. ICD and these criminal divisions, they are all the same. High court with unlimited jurisdiction. I wouldn't expect that from him again. I wouldn't. That submission, my lord, is neither here nor there. In other words, he's suggesting that actually the land matter can find its way here, or a family cause. There is a family division. There is a land division. My lord, can you handle land matter simply because it's high court or commercial transaction? So the instruments establishing these divisions of the High Court are redundant. They are made in vain, superfluous. For the record, my lord, ICD is a creation of the law. It is the Constitution, the High Court, in bracket, International Crimes Division Practice Direction, 2011, and in the recital there, my lord, you will see, made under Article 133, Clause 1A and B of the Constitution of the Republic of Uganda. The High Court, International Crimes Division Practice Direction 2011, made under Article 133, Clause 1AB of the Constitution of the Republic of Uganda. And in Clause 3, Paragraph 3 of that practice direction, establishment of the division. The division established in 2008 under the War Crimes Act, no, under the International Criminal Act, International Crimes Act rather, as the War Crimes Division, is hereby designated as the International Crimes Division. And my lord, there are rules, specific rules regulating the processes or the procedures before that court, which are totally different from the rules governing this court. And that is the Judicature, in bracket High Court International Crimes Division Rules of 2016. They are quite elaborate and detailed rules. I don't want to labor you, to waste your time, my lord. And my lord, the peculiarity of this court, the uniqueness of this court is not only seen in the processes and procedures provided for under the rules, but even the composition of the court.
I just want to end by referring the court to Article 129. It begins at 126, but the most instructive is 129. Judicial power of Uganda. 129. Courts of judicature. This is a court of judicature. Judicial power of Uganda shall be exercised by the courts of judicature, which shall consist. So what I want is just the word of Uganda, not of Kenya, not of any other country, just to indicate the territorial limits of your jurisdiction. So that when A1 says it is one illegality upon another, the court is able to grasp. I cede ground to my colleagues. I know that Mukwago and Kalibara and you.
May it please you, my lord.